Good morning. I'm Gary DeWaal, and this is Bridging the Week for December 12th to 16th, and today is December 19th, 2016. Last week, a broker-dealer settled Securities and Exchange Commission and New York Attorney General charges that its marketing of an order routing system was misleading when it failed to disclose to its clients and prospective clients that, because of a data coding error, the system failed automatically to evaluate different dark pool trading venues for optimal execution of orders as promised. Meanwhile, the CFTC obtained a summary judgment decision that a trader's prearranged trades to transfer profits from her employer's trading account to an account of a company owned by her mom violated applicable federal law and CFTC regulation. Most of the Midwest and Northeast United States experienced unusual cold last week. So I can enjoy the warmth for the next 2 weeks of year-end holidays. Let's get started. Deutsche Bank Securities, Inc. settled charges brought by both the Securities and Exchange Commission and the New York State Attorney General that, from January 2012 through February 2014, it failed to disclose that an order routing system it used, known as Super X Plus, to direct orders to trading venues commonly known as dark pools, was not operating in the manner disclosed to clients. Specifically, according to the regulators, Super X Plus was meant to route orders based on a number of factors, including a client's own instructions and an algorithm, named the dark pool ranking model, designed to evaluate execution quality and liquidity among different possible trading venues. However, because of a data coding error, Super X Plus did not perform as intended during the relevant period, said the regulators. The regulators alleged that Deutsche Bank Securities continued to promote to its clients and potential clients during the relevant time that its ranking model performed as designed and failed to disclose the algorithm's malfunction. To resolve this matter, Deutsche Bank Securities admitted all facts alleged by the regulators and agreed to pay a fine of $18.5 million to each of the SEC and the New York State Attorney General's office. The Commodity Futures Trading Commission prevailed in a lawsuit against Yumin Lee and Caring Capital Ltd., a company formed by Ms. Lee's mother, that claimed that Ms. Lee engaged in multiple illegal futures transactions from March 17th to May 6, 2015, designed to transfer $300,462 from an account of her employer to an account in the name of Caring. Ms. Lee argued that because her employer, quote, did not appropriately compensate her, end of quote, she engaged in illicit transactions, quote, to obtain compensation which she believed her employer owed to her, end of quote. In response to the CFTC's motion for summary judgment, the court said there was no dispute of facts and that Ms. Lee engaged in fictitious trades in violation of law and failed to execute futures contracts, quote, openly and competitively, end of quote, as she was required. The court held that Caring was fully liable for Ms. Lee's violations under the provision of law making a principal liable for the acts of its agent, as Ms. Lee was also employed by Caring during the relevant time. As penalties, the court ordered disgorgement of $300,462 held by Caring and a civil penalty of $901,387 against Ms. Lee and Caring. Ms. Lee was also subjected to a 5-year trading ban. Joseph Taub and Eliezer Shimolo were the subject of a criminal action filed by the United States Attorney's Office for the District of New Jersey and a civil action filed by the SEC for their role in an alleged manipulative stock scheme that netted them $26 million in profits. According to the regulators, from at least January 2014 through the present, the defendants typically used one account to place many small lot orders in a thinly traded stock in order to drive its price up or down, in order to effectuate their purchase or sale of a larger quantity of the same stock in another account at an artificially beneficial price. To disguise their activities, claim the regulators, the trading accounts used in each parent activity, which were variously the names of the defendants, family members, or companies the defendants controlled, the two trading accounts were held at different broker-dealers. At times, alleged the U.S. Attorney's Office, defendants, quote, controlled more than 80% of the volume of a targeted stock, end of quote. Defendants could face up to 5 years imprisonment and a fine if convicted of their criminal action. The SEC seeks a permanent injunction against the defendants, as well as disgorgement of profits and fines. Both legal actions were filed in a federal court in New Jersey. And finally, the SEC resolved charges against Paul Davis, Chief Executive Officer, Chairman of the Board, and 35% owner of Wilson, Davis & Company, Inc., a registered broker-dealer, and two of Wilson Davis's registered persons for their alleged role in the purported violation by the firm of Regulation Show and the SEC's market access rule from at least November 2011 through May 2013. The SEC charged in a separate complaint against Wilson Davis, which was not settled, that during the relevant time, the firm routinely effected short sales in securities on its own behalf without borrowing the security or entering into a bona fide arrangement to borrow the security, or having a reasonable basis to believe the security could be borrowed for delivery by the date the securities was required to be delivered, as required by Regulation Show. The firm said that it was exempt from such a requirement because it was a market maker. However, charged the SEC, it was not. In addition, the SEC charged that, during the relevant time, the firm did not maintain systems and controls in connection with its direct access to exchanges reasonably designed to manage the financial, regulatory, and other risk of having such access as required by Reg Mar. I have some background on Reg Show and Reg Mar on the article version of Bridging the Week on the website. Check it out. The SEC charged Mr. Davis for signing a required certificate in all years from 2012 to 2014, saying that Wilson Davis was in compliance with Reg Mar when it was not, and the other registered persons for violating Reg Show and Reg Mar, respectively. To resolve the SEC's charges against him, Mr. Davis agreed to pay a fine of $25,000 US. The other registered persons settled for larger fines and disgorgement of profits too. Well, that's it for this week's edition of Bridging the Week, let alone the last video version of Bridging the Week this year. As always, there's more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week. Enjoy the holiday season. And until the next edition of Bridging the Week next year, ciao.